computer.
Hey,
All right. Good afternoon, everyone. This is Curt
and Brad Pinsky.
And we are here for another edition of Fire Law Roundup. My apologies for this not going out live. We spent the last 15 minutes trying to get this thing to work on YouTube. There's an interconnection between Zoom and YouTube, and for whatever reason, it's not cooperating. We get hung up as soon as we try to go live on YouTube. So what we're going to do is record it, and then I'll post it as soon as that recording becomes available. So, but Brad, another interesting week. Didn't seem like any major cases this week, but certainly some interesting ones.
Yeah, some that are interesting and some that get under your skin. So, but this will be pretty quick, except, there's a couple we should dig into. But let's start with Washington. This is just the most bizarre case. I just have there are two things I don't understand about it. But here we have the city of Bellingham had
well, I'll tell you what, I've been following this right along. If you want me to kind of go through it,
because I can't do it without laughing, and I apologize to everybody, including the dead body.
It goes back to 2018. I've got a number of different entries. I think there's probably 8 or 9 different legal proceedings arising out of this, because we've got certainly the civil suits that we're going to talk about here, but we've got some state EMS disciplinary action. We have fire department disciplinary actions, and a lot of different legal issues have come out relative to this case. But what we have is apparently in Bellingham, Washington, the fire stations can be used to basically hold bodies until the funeral home can arrange to pick up the body. So that's sort of problem number one. Problem number two, which I totally understand from a clinical perspective, is that the firefighters or the medics in particular would use cadavers for training, to practice intubation skills and different things. One of the things about cadavers is you're supposed to have consent, and you don't just find a body and say, "Ooh, let's practice intubating." So at any rate, they had a gentleman who passed away, and there's no question about that as, being an issue. He passed away, but the firefighters, the body was left at a firehouse in Bellingham. Is that where one of our friends' spouse was a firefighter, by the way?
It's sounding familiar, but maybe
Bellingham. I think it might have been where Dr. Beth was a firefighter. At any rate, they practiced intubating on this body. In fact, there was some of the articles about it mentioned the fact that even non-paramedics were practicing. They allowed a administrative staff member to give it a shot. But bottom line is, somehow the family found out, and there were claims that were filed by the spouse, by the children, and by the brother of the man who passed away. And subsequently, those led to lawsuits, civil suits, and all of them were settled. The suit against the fire department, and also they named some of the firefighters. 11 firefighters were named in some of these, but the suit by the wife was settled for, I think it was $175,000.
And that's the only one I get, by the way.
Well, okay. And then the kids, the children, and again, what we're talking about, I believe the claim that there are some due process claims, invasion of privacy and so on under the Constitution, that kind of open the door to federal court. The tortious interference with a corpse is more of a state law claim. But then there's intentional infliction of severe emotional distress, negligent infliction of severe. There's a bunch of different ways that creative attorneys are going to find a way to go after the fire department and the personnel. So at the end of the day, the wife's claims were settled. The kids each got $75,000 each. That was settled. But the one kind of joker in the deck was the claim by the brother. And you kind of suggested it, that, how does a brother, you can see the spouse, you can see maybe the kids, but where does the brother? And the suit was filed. I thought an interesting part of this was the suit was filed in federal court because they were alleging certain constitutional violations. Because again, the fire department is part of government, and when government does something to a private citizen, it raises constitutional concerns. So
even a dead one.
Yeah, well, the dead one isn't the one who's suing, and that creates a little more complexity, because now the family members are the ones that file a suit, and they've got to allege a violation to them, not to the dead person. The person's estate could file, but they're alleging that they were harmed, not the estate was harmed, because the man was dead. They have to allege that they were harmed and that they suffered emotional distress and so on. Bottom line is, big issue was, does the brother have standing to bring the suit? The brother filed the suit in federal court. The federal court now has to look at state law, Washington state law, to determine whether or not the brother has standing under Washington state law. And the federal court said there's no case law here. We don't have a way to determine that. We're a federal court. We deal with federal issues. Yes, we'll handle some state claims, but we don't have basically the jurisdiction to create law in Washington. So what they did was they did a procedure, which, attorneys know, is you certify the question, and both parties will negotiate what is the question that's going to be certified. And then that question then was sent to the Washington State Supreme Court. And the question was essentially, does the brother have standing to bring a claim like this? And I believe it was March of 2021, the Washington Supreme Court said, yes, the brother does have standing to bring this suit. So this has been kicking around. The incident happened in 2018. This has been kicking around now for 5 or 6 years here. And finally, Mr. Fox got his day in court. They start the jury trial, because again, in 2021, the Washington State Supreme Court says in Washington, the brother of someone who has this happen to them has standing to bring the suit. Amazing. And so now the trial starts. Apparently, Mr. Fox was on the stand. He talked about the emotional distress and the pain that he suffered as a result of knowing that his brother's dead body had been intubated repeatedly for training firefighters. And shortly after that, the case was settled. The parties must have adjourned. The offer was made. Mr. Fox accepted it, and it was for, magically, $175,000, basically the same as the victim's wife had received.
And I don't even know what the lesson is here. If you have a dead body in your firehouse, don't mess with it.
Well, that's part of it. But I think that sometimes we get very clinical. We get very objective and removed from the emotional connection with this. And we say, oh, wow, we got a body here. We haven't had one in a couple of months. I haven't done my intubation, or maybe I was a little shaky the last time I did it. Let's train, or maybe we have some new people. Let's do some practice. And it's not, you're not intending to desecrate the person's body. You're intending to improve your skills and be able to be better at what you're doing. The missing component there is an understanding of the legal implications. And, we've got to understand that, dead body, beyond just being a corpse that we could use for training purposes, is a person that there's people that are going to be upset.
And look, I view this as a different way. I was surprised that there wasn't a potential criminal action, right? It decided, because there's got to be a cause of death determination, presumably. I don't know anything about Washington state law, but presumably—
I'm going to check my database while you talk, because there may well have been, it's just slipping my mind, but go ahead.
Okay. Right. I mean, the obvious issue on the criminal side is you've got a dead body. There's no cause of death yet confirmed. The ME hasn't done an autopsy or a confirmation of the cause of death. And so you're messing with the body, right? You're altering potentially a body. If you broke a tooth, if you hurt their, lungs somehow through intubation, whatever you're doing, you could be not desecrating a body, but hurting a body. So I usually try to find these lessons in everything we do, and usually I can, but this one is pretty unique to the state of Washington. I'm not sure how many other states have dead bodies brought to firehouses, but nonetheless, if there's a dead body anywhere, and you don't need to touch it, don't touch it, right? Because you could be altering the cause of death. Unless you're trying to save the person, or remove them from harm or, something in the line of duty. Let's not mess with a dead body. And in many states, right, many states have criminal actions related to what you've done to a dead body. And New York has a whole bunch of things. It's kind of gross, a litany of things you could do to dead bodies, which you shouldn't do, which you could be criminally charged for: burning, desecrating, having sex with. I mean, all bad thing. What does they call it? Necrophilia, right?
Yeah,
all bad things don't do to dead bodies. And practicing on them, unless they're donated or, unless there's consent and a release and all the things, don't touch the dead body. So if a dead body's in your firehouse or anywhere else, leave it alone.
Yeah, no, absolutely. I just checked. I've got a total of 6 cases, and there may be additional legal proceedings that have spun out of this because a couple of people lost their job. There may be some things. I try to keep track of all the suits involving the fire service. I inevitably miss some, but I've got 6 related to this particular incident, and none of them are criminal. So at least to the best of my knowledge, and certainly if anybody out there has better information, send me the information. But as best I can tell, there was no criminal charges. There very well could have been, and in other states, there may very well have been.
All right. Let's go to DC, because this one, at least I understand. This is more common, and in truth, I got to tell you, I have a lot of blame around. So here we're in Washington, DC, 2 firefighters, and the facts are kind of important here, but basically 2 firefighters are facing discipline because they allegedly delayed the response to a chest pain call because they had already placed an order for food, and they fast food, Chick-fil-A or whatever, and they pulled over for a minute or so to pick it up. They said they were famished, they were tired, right? But meanwhile, they'd been dispatched to this 57-year-old female with chest pain, and this was an ALS ambulance. So if you watch the news footage, you see, it's funny, you almost got to pause it to see what they say, but they claim, look, there was no delay of care in the report from the fire department, which really wasn't true. As the news report doesn't appear to be true, the news report, there were 2 units dispatched. The ambulance alleges, I believe, if I understand it correctly, that they were kind of a supplemental response, except they were closer than all other units. So they were dispatched as the closest available unit. I think the important part of this, look, obviously, if they delayed care and there was an injury to the person, we don't know from the delayed care, there's probably going to be a lawsuit. On the other hand, let's talk about better municipal practices, because this is where I see this going. You cannot run your EMTs, paramedics ragged. Fire is a little difficult because there's, you're probably not going to say, okay, your fire truck's out of service, go to another station. But another ambulance, you got to give them, and I don't mean under law, but yet practically you have to give them time to eat. You can't starve them because it does impair their judgment. They're tired. They're not going to think as well, act as well. So I think the municipality has a really good incentive in order to help prevent negligent care, treatment, et cetera, to make sure that your personnel are fed and rested and given at least some break. And yes, fine, FLSA, maybe there's not a requirement when you're on the ambulance to get a half an hour meal, right? But here you really need to allow them to have a meal. And I think that's a bigger issue here because they did make a bad decision, right?
I agree. And this incident happens all across the country, not necessarily being dispatched, but units sort of self-policing the issue by not calling available and not becoming available and keeping themselves out of service so that they can get a meal, they can get a break. They can use the facilities or whatever euphemism you want to say, but there's some things that people have to do. And often I think administrators are just either oblivious or they're under such budget pressure that they cannot provide enough people to allow people to have lunch, have a break, just take a breather, and even use the bathroom. It's just, and you're right, it is, at some extent, it is on the leadership. On some extent, it's on the political entities that don't provide enough resources to allow people to even take a break.
Right. And we're not excusing, right? We're not excusing the medics for, accepting the dispatch, had they just said to the dispatch, we need to get food. Is there anybody else? Something, as opposed to saying, we're in service, we're going. You can't do that, right? So there's sympathy on either end, on all ends. Ultimately, though, once you're dispatched, you either own up and say, listen, we just can't go. We can't handle the call right now. Then it would be a different issue. Be honest about it. And, you know, I was freeze framing on the little bit they showed of the incident report. And I was trying to read it. And there's a question, not in my mind, there's a question of whether the medics were truthful or not. Obviously never lie, just own up to it and say, you know, we're starving. We couldn't go on any longer. And it probably would have been better, who knows, but at least be honest, right? Even if the truth doesn't help, be honest. That it never helps when you put yourself in a situation where you're trying to explain the truth or what's not the truth. But agree. I think you and I take the same view that this is a bigger issue than just this one ambulance. You've got to give people time.
You've worked on rescues.
20 years.
You know, you've got extensive experience. I have worked on them. I haven't done a lot on them. I've been on busy engine companies, but I haven't been fully assigned to a rescue. I've done a week here, a week there, and, you know, that was enough for me. God bless the folks who want to do that for a career, okay?
Right.
But the people who've done it have a different perspective on a story like this than the people who've never done it.
Right.
And unfortunately, many times the people who haven't done it are the ones that are calling the shots, or in this case, covering this. Paul Wagner, who is a very good reporter from the DC area, and he covers a lot about the fire department, but he's never, I mean, maybe he has been, it just doesn't seem to me he has actually done this. So he doesn't truly understand what it's like. On the other hand, the medics probably don't understand what it's going to be like when a guy like Paul Wagner gets a hold of a story like this.
Right. Right. And look, I agree. I mean, these weren't tricks. What we did is we would not clear the hospital. We would pick up the phone, call them saying, we need to get lunch.
This is our 18th run in the last 12 hours. We need a break.
Right. And we leave ourselves out of service at the hospital. Right. And then we go and then we call ourselves back in service or whatever, but you don't mark yourself back in service. Now, however, there was reference, and I don't know what they do in DC, but there was reference to that they were tracking their location. They could see where they went and how long they were there. So obviously, maybe they automatically take them out of service, right? Or put them back in service from the hospital. Now, I will tell you, in New York, in my area, it's become a real big issue because as soon as our ambulance and any other ambulance leaves the hospital, which is in the city of Syracuse, right? And we're 20 miles away for our territory. So we leave the city, we can be dispatched, all ambulances here in Onondaga County, New York, can be dispatched anywhere in the county. And it's happening all the time. Hey, you're clearing the hospital, go here.
Yeah.
And yet these are people who probably do need to get lunch or dinner or rest, and they're being sent to a call that's not even in their own territory, that's fully a different municipality. And, you know, dispatch is just sending them because they cleared the hospital. So whatever it is, this is a good time, I'm saying to DC, to look at your policy, look at your procedure, and let's get this right. And as to all providers, don't lie, right? We get it, but don't lie.
And take care of your people.
Take care of your people.
Take care of your people. Absolutely.
Absolutely. Okay. Let's, a 2-second comment, just that there's, yet more AFFF and PFAS suits, one in your area, Rhode Island, and the North Collier Fire Control and Rescue District, which is in Florida. This is just, 2 more suits among the hundreds or thousands that have been filed, but I don't think we need to spend much time on that.
I took a look. I've got somewhere around 40 suits by fire departments, and I was really kind of taken aback. I thought I had 2 or 3 times as many.
There are 2 or 3 times that many.
Oh, I'm sure there are, but I'm just going based on my database.
Oh, okay.
And I was really kind of like you. I was like, wow, that's not very many, 40 or so. But I'm not sure that I catch all of them. I catch them when I can, but I'm sure I don't have all of them.
Well, some of them are kind of class action, right? Some of them are many fire departments in one suit.
There's been several where there's been 40, 50 different fire departments added in. Yeah. But I would consider that to be one suit. I don't consider it to be 50.
Right.
So, yeah.
This is the most interesting case we're going to talk about today. This is really interesting. And I like comparing this case with other states because this is insane. So let's go to Connecticut. We're here. The public information officer went to a scene with a camera, takes pictures, took a picture of a scene, right? And they're then charged with a crime. Now, forget the fact they're charged with a crime because they actually did violate the law in my reading of it, but the law is insane. I don't know what your take is, but let me look at the law. So what the law says, it's an either or. All right. It says any peace officer or firefighter, here we probably have the firefighter, or EMT, paramedic, etc., who responds to a request for medical or other assistance and in the performance of her duties, right? Other than in the performance of her duties. This is, I think, the saving language. So while not in the performance of their duties, takes photographic or digital images of the person without their consent. That's one. Or while not in the performance of their duties, then transmits, disseminates, or otherwise makes available to a third person the photographic or digital image, right? So basically this is, if you're a firefighter and it's not your job, or an EMT or a paramedic, whatever, and it's not your job to take pictures on a scene and you do so, either you take the picture, you could be criminally liable to a fine or imprisonment up to a year, or if you distribute, right, you receive a picture and you transmit it, disseminate it, etc. So what's amazing, of course, to these, as you point out, this is the public information officer. This is exactly the scope of his duty. Right now, they may get into what is the duty of a PIO. Normally, the duty of a PIO, I guess you could argue, like in the police side, is to report, not to take images and say, hey, here's what we're doing, right? But here, that's the PIO's job. And this went on for a long time. Finally, the charges, I believe, are dropped, right? But I can't imagine, as you rightfully point out, I cannot imagine what this person went through being criminally charged for doing their job.
Well, I've had the opportunity to speak to Steve, and my hat's off to him. I think he exhibited a great deal of patience with what I would consider to be incompetent police work and incompetent prosecution. There is no justification for what the state of Connecticut put him through in this case. At best, there's an ambiguity in the law. To me, it's very clear. He took the pictures, and as you went through the law, folks can go on the blog and read the law. He took the pictures in the performance of his duties as the PIO. He shared the pictures in the performance of his duties as the PIO. He didn't post them on his personal Facebook page. He didn't forward them to a friend or whatever. He did exactly what the law requires. And you're talking about having to prove something beyond a reasonable doubt. You're talking about charging somebody with a criminal offense, which maybe a prosecutor can say, oh, well, that's no big deal. That's like, maybe to you and I, we say, oh, a house fire is no big deal. Well, it's a big deal, the person whose house is on fire, and it's a big deal to charge somebody with a criminal offense. There's all sorts of implications when you charge somebody, including, and you and I are both, Second Amendment advocates, but that can jeopardize your ability to carry. You have to, very cavalier attitude by the police and the prosecution in this case. And I think they both ought to be called to task for that. That's to me, this situation is unforgivable. And I hope to have Steve on one of my podcasts or vlogs in the near future to discuss what he and his family went through.
That's a good point, because I often tell people and I think we had it on our last or a couple times ago, I talk about people have no idea what it's like to go through a lawsuit. Yeah. It is grueling, and nobody should want to go through the discovery and all that, but a criminal prosecution is different. But, it's almost a malicious prosecution, because you got to figure out, the only question here, was he in the performance of his duties or not? And all that takes is one letter from the chief, right? One phone call to the chief saying, hey, is this the guy's job? Was he paid? Is this in his job description? Has he done this before, right? What is his job?
Wouldn't you think the police and prosecutor would want to know that before you put handcuffs on somebody?
Right.
You know, that would be part of your investigation.
if there was an investigation versus a slap, a slapstick kind of Keystone Cop maneuver where they just say, oh, we're just going to arrest you because we want to.
Yeah, just terrible, just terrible.
Yeah. So I feel badly for the guy, and I think it would be interesting to hear. But obviously this is just bad police work, and I don't know how this happened, but just
let me just take a 50,000 foot view. I want to take a step back and take that 50,000 foot view. There's 4 states that have laws like this. Yours is one of them. New York recently is the most recent addition to it. But we've got New Jersey. Connecticut was actually the first. New Jersey was the second. California and New York. Okay. To me, laws like this represent a failure of leadership in the fire, police, and EMS organizations, because the chiefs have failed to manage this problem effectively. They've permitted this to happen to the point where the legislature feels we have to do something. The police chiefs, the fire chiefs, the chiefs of EMS, they have failed to manage their people. And if they can't get this kind of picture taking, inappropriate, and I don't mean Steve's picture taking, but I mean inappropriate picture taking, inappropriate sharing to stop, then we as the legislature are going to fix it. And this is the result. And, I use this, folks who've been in my classes before on digital imagery will recognize it. But when I first got on Providence, one of the chiefs had been, he was part of the greatest generation, and, had been a soldier in World War II, hit the beach in Normandy. And, but he had a saying, okay? And it had nothing to do with digital imagery. We didn't even know what digital imagery was back in 1979, okay? But we were talking about something that was going on, and he said, listen, what folks don't seem to understand is that we have to keep our own house clean. If we don't keep our own house clean, the legislature is going to come in and keep it clean for us. Right. And actually, he was talking about the fire chief, but he was talking about the way things operate at the station. He said, we either keep our own house clean or the chief's going to come in and clean it for us. And we're probably not going to like the way the chief wants to keep the house clean. So let's keep our house clean. Again, he wasn't talking about housework, but he's just talking about the nonsense that can happen, that if we can manage things at a station level, the chief isn't going to have to come in. And it's the same principle here with the legislature. If the fire departments and police departments and EMS agencies can manage the picture taking, then the state legislature doesn't feel the need to come in. But if we don't, you can expect that you're going to have stupid laws like this enacted.
Yeah, but although I got to tell you, in some sense, it's not just about our own house, though, right? Because it's about the people we can't necessarily control, the off-duty people or the mutual aid people, but it's people who may not be under our control at that time come in off duty. And, I was just working with a department in Maryland. I obviously can't mention their name, and we're working on their digital imagery policy. And they're like, well, but people come all the time and they take pictures. And, sometimes we allow them to stand inside the, medium zone there, right? Not the cold zone, not the hot zone, but the warm zone. And I'm like, you can't do that. You can't grant someone access and come take pictures, right? In that the public couldn't otherwise get access to. You just can't do that. And he's like, well, if we don't, they're going to take pictures of everything, whether we let them or not. I'm like, you know what? Then that's on them. But you facilitating them taking pictures, but that was them trying to control the problem. Right. And because they recognize there's a problem with off-duty personnel coming to a scene, taking pictures for the hell of it. And here's kind of my question. So now you have an off-duty personnel. Mm-hmm. This law applies as well to off-duty personnel, right? Showing up, taking a picture. Doesn't apply to the public. No,
it can't. It can't. And I would say an off-duty member has a First Amendment right to take pictures.
Well,
and
then let's look at the law.
This law could not be applied to someone who's not on duty. It could only be applied to someone who is on duty. That would be, and that was, Steve got himself one of the top First Amendment lawyers to help out with this case in the country. And that was considered to be one of the issues here. And I think if they had tried to prosecute someone who is not a firefighter or an off-duty firefighter, they would have run into a problem with the First Amendment.
And I guess the law in this section, they say if the first responder responds to a request to provide medical or other assistance, right? So they're putting him in on duty, presumably. I'm assuming that's why they're trying to say, you're right, you respond while on duty to a request to provide medical or other assistance. That's to probably challenge or make clear this isn't just, right? This is in the workplace, not to every member of the public.
This is the problem when we don't manage our own problems and somebody tries to fix our problems for us. And again, I'm speaking to the chiefs out there. Don't wait till you have a problem. There's already plenty of cases where fire departments have gotten themselves in trouble. There's some cases I can point to you where fire chiefs lost their jobs because of the picture taking and sharing that happened by subordinates. So, you know, you need to have a digital imagery policy. We need to educate our firefighters, but also our officers, and the officers need to understand the risk to the organization and maybe to them of not properly managing this problem. Or we're going to see more, we'll have all 50 states that have stupid laws like this.
Yeah. And I get the point of it. You know, I know we say it's stupid, whatever. I get the point of it. It just shouldn't have to come to this, right? Be respectful.
It shouldn't, you know.
What I tell people is, it's same with HIPAA. This isn't your emergency, right? This isn't your situation. What you're taking pictures of isn't yours just because you respond to it, right? So somebody's privacy isn't now your privacy to flaunt to the public, right? If you want to take a picture of yourself doing something without the patient, hey, maybe that's fine, maybe not. But you put the patient here, they didn't ask to be, right? Just because they're involved in a bad situation, fire, medical emergency, car accident, whatever, doesn't mean they want to be put out to the public. So I don't know what mentality that firefighters and ourselves have to say, oh, I went to this person, I'm a public servant, so I get to put it on my Facebook page. What kind of insane thinking is that?
We don't recognize it. I think one of the things I try to do in teaching is to kind of give sort of an analogy that removes us from what we do, because sometimes we're so close to something we can't really be objective about it. So here's let me give you an example. Okay, the cable company, you have a problem with your cable. Okay, the cable company guy comes into your house and is working, running upstairs, running downstairs, checking wires. Okay, in the meantime, he's taking pictures of things that are going on in your house.
Right.
And then the next thing you know, all these pictures are showing up on social media. You would be outraged, absolutely positively outraged. Okay. What's the difference? Because you have a badge and a uniform?
Right.
There's no difference. Okay. And again, it's about education. Okay. Folks have got to be educated on this. They got to kind of think it through and, you know, behave accordingly.
Yeah. Well, like you said, if we don't clean up our own house, someone's going to do it.
Somebody's going to do it for us, man.
Yep. Okay. So, boy, I hate this. I hate this case. I hate that it happened, but we're going to go to Missouri. It's our last case for the day. Here it's a jury verdict. So we have had a trial. There's a deceased Kansas City, I think paramedic. Who had PTSD. And I know you're saying deceased. Well, everyone hold on, right? So the individual experienced PTSD from a traumatic call that happened back in, I think, 2014. The person was then assigned to desk duty and alleged, although was found, right? Now we have a jury finding that the medic was subject to bullying by a supervisor, which if that happens, you lose automatically, right? Supervisor or officer harasses you, you lose. It's not a question of whether the organization knew it was happening because the supervisor did it. They're deemed to know. But nonetheless, he was the individual, Giovanna, was subjected to bullying, some retaliation. It was reported. The supervisor was not disciplined. So the now deceased medic files a discrimination complaint with the EEOC. Unfortunately, in 2018, they found her body, and there was a fitness for duty evaluation report that was found right on her bed where her body was. So they sue. A jury awarded $100,000, not insignificant, Frankly, the legal fees were probably twice that. I'm surprised they didn't settle this when you're talking about 100,000, but who knows what they asked for. In any event, the jury awarded $100,000 for basically disability discrimination, retaliation, harassment, bullying. And this should never happen. I never will understand. And by the way, usually I use the term alleged. This isn't alleged. The jury came to a conclusion. So we're going to say this was done. I don't understand how we eat our own. I don't understand how we beat up our own. We're there for the community, but we destroy our own people. I'll never understand that.
I do want to make it clear that this was, she had been complaining about disability discrimination. She alleged that she had PTSD and that she was being discriminated against and then retaliated against because of disability discrimination. This is not a wrongful death suit. So there was no need to prove that the bullying led to her suicide. So that was not part of what was going on here. This was a discrimination suit that started when she was alive, and her family pursued. Okay, it wasn't clear
her
from
name,
coverage.
presumably.
Yeah, it wasn't clear from the news coverage about it whether or not she had actually filed the suit or just filed with the EEOC prior to her death. But at any rate, her family picked it up from there and pursued the claim. There's so many aspects to this, because I understand from a front office and a fire department's perspective that you have people that you feel are malingering, that don't want to work, that are looking for excuses. Maybe they're difficult people or whatever it may be, and that you feel that there's a need to keep track of them and let them know that you're paying attention to them. And I think, how do you do that when you think somebody is malingering? And I think that I'm assuming that that's what the supervisor believed. There's a sense sometimes that you've got to make it difficult for them. They're in a staff position. They're in a non-line position. They don't want to go back, or they claim they can't go back. How do you manage that without going beyond and creating a situation like this?
And the simple thing is, you treat them like they're not disabled. You give them a job, you give them an assignment, you evaluate them based on their performance. You write them up if they're not performing, right? But you judge them only upon their abilities. If they're at work and fit for duty, right? If they're on the desk job, presumably the psychologist has said they're fit for that duty. So if you're fit for the duty, you get a fair, unbiased, non-retaliatory evaluation of whether you're doing the job or not. If you're not doing the job well enough, you get retrained and counseled and evaluated again, and
Brad,
then at some point let go.
Can I stop you there?
Please, yeah.
How many fire departments are providing the training that Brad just described? All right. You're exactly right that supervisors need to hear someone like Brad or someone with an understanding of this, making that case clear to the officer before they're put in charge of someone like this. But we don't do that. You take a written test and now you're a supervisor, okay? Or whatever process you go through, but with very little, if any, training on exactly what you just described.
Yeah, and let me say that there's a big difference in the law. People should understand this, at least in New York, and I'll imagine in most other states. If you file for, let's say you're terminated, and you file for unemployment, the question is, were you terminated because you didn't do the job well enough, which is one thing, or you refused to do the job? If you have somebody who refuses to do the job, now that's insubordination, right? That's not incompetence, that's insubordination. And that's a terminable offense. So if they refuse to do the job, then you treat them accordingly, and however you would treat insubordination. If they're not doing the job well enough, then you have the obligation, the legal obligation in many states, to train them, counsel them, right? It's not a disciplinary matter. They're trying to do their job. They're just not doing well enough. And if then you need to reassign them to a different job, which they're capable of. And if there's no other job and you can't train them, fine, we'll terminate them if that's allowable under a CBA or state law or whatever. But there is a big difference between I don't want to do the job versus I'm not able to do the job well enough. But in none of those circumstances is bullying the appropriate, or retaliation the appropriate reaction. If somebody's lazy, then you give them an order to do something. And if they don't do it, you treat them as insubordinate. right? There are ways to handle this. And the reason I'm saying all of this is because I think that we believe in the fire service and other services that denigration is motivation.
Right.
That's the problem. I like that quote, right? But denigration is not motivation, and bullying is not an incentive to work better. It's harmful. So if you want to help them do the job, help them do the job, but don't denigrate them as a way to motivate them. It's like the coach, right, who says you're horrible, you're never going to amount to anything, and now go out and win it.
Yeah.
It's just not going to happen.
Well, and that's a great point. I think part of the training that you mentioned, okay, and this is something I incorporate into mine, is an understanding that people can perceive something differently. And we all kind of know that, but we all tend to, we tend to discount it. We tend to discount that someone can hear basically a supervisor, maybe whether it's criticism or whatever, and feel that it's bullying. Or you could have a supervisor that is not being critical, but it's being perceived as bullying. And let me give you, I know that sounds like baloney, okay? Sounds like airy-fairy stuff, okay? But you're from New York, I'm from Rhode Island, I'm a Red Sox fan, I'm making an assumption you're a Yankee fan, okay? When you and I are sitting in the stands together at Yankee Stadium or Fenway Park, either one, and there's a close play at second base, you're going to see it one way and I'm going to see it a different way.
Right,
and there's no amount of talking. There's no amount of talking between us that is going to cause us to see it differently. And that is how different people can perceive the same thing differently. And when you have someone, and whether it was the victim here or whatever, is perceiving things as being bullying, that is her reality. And our supervisors have got to understand that. And again, it's not going to be one thing on one day. It's a series of things, just like in this case. It's a series of things over an extended period of time that are said, that are done, that are perceived in one way. They're said in one way by the supervisor, and they're perceived in a different way by the employee. Right. Bottom line is, we've got to include that kind of training of our supervisors so that they can recognize when they're getting themselves in a jam with an employee like this. And you get legal help, you get HR to help out. So it's not going to be perceived as one particular supervisor picking on or bullying one particular employee.
Well, and you know, let's, at least my kind of closing comments to this are, how many departments have matrix-based, I'm using that phrase for a reason, matrix-based job performance evaluations? If you do not have, right, and matrix-based, I mean, how timely are you something, right? How correct in spelling is it? How complete is it? How whatever, right? Objective, somewhat subjective type evaluations versus, am I doing a good job? Yes, no, right? And on a scale of 1 to 4, how good are you? You know, those are ridiculous. But when you have, like, I have job performance evaluations, and I think they're probably, that I used, I got my union to accept when I was chief, and I think it's probably about 10 or 15 pages of very specific examples of, and very specific questions of how well are you doing something, and it monitors each thing. Those job performance evaluations at least will hold up in court. Now, yes, you can always say, well, they're negative, right? Or you're intentionally, you know, harassing, or you're intentionally giving me bad evaluations. But the alternative is what? The alternative is, well, you made this comment offhanded to me this way, or you kept referring to me as Lazy Joe, or you kept saying these things about me. Look, I like job performance. Look, we told you you were not doing a good job. We asked you to work harder at these things and improve at these things. Here's your second job performance evaluation. You didn't. So now we've fired, reassigned, whatever, as opposed to this bullying, harassing. But the reason I raise this is, I'm wondering if people who make these bullying, harassing comments, I'm not trying to protect them, but don't have another outlet to voice their criticism of the people, right? And a job performance evaluation, a good one, allows you to voice your criticism in the hopes that the employee recognizes it and will get better. But if you don't have one, what's your alternative? Offhanded, obnoxious comments. So my lesson, at least, is get some really good job-based performance evaluations. I will share mine that I've done. I've stolen part from other places, but mine was reviewed by our union and criticized, and we worked together because they wanted job performance evaluations, right? That would help them be better because it also protects their job and makes them better, and helps them in terms of promotion, discipline, whatever. So if somebody wants one, I'm happy to share it for our 1,000 or so subscribers and more listeners. But you got to have something. You got to have something.
All right. Well, any final comments? So we
that was it. Don't mess with the dead body in your firehouse.
Yeah. Yep. And all right. Well, that's going to do it then for another edition of Fire Law Roundup, and we'll see everyone again next week. We're closing in on 1,000. I think we only need about 14 more folks to subscribe, and we'll be at 1,000 subscribers. So really appreciate your likes. We really appreciate your shares and also your subscribes. Okay. That'll do it for another edition. Brad, we'll see you next week.